This is my judgment. Uganda is a constitutional democratic country which evolved from a British protectorate declared in 1894. On Tuesday, 9th October 1962, the country attained its independence from the British and became a sovereign state. Its independence constitution became the supreme law of the land. That constitution was amended in 1963 to create the office of a constitutional president. In April 1966, the constitution was suspended and later abolished. It was replaced with an interim constitution in May of that year. The interim constitution paved the way for the 1967 Republican Constitution on the 8th of September 1967. The 1967 Constitution remained in force until 8th October 1995, when the presidential elections held since 1996 and has each time emerged victorious. Since the reintroduction of multi-party politics in Uganda in 2005, the National Resistance Movement Party, with President Museveni at its helm, has consistently won the majority seats in parliament sufficient to garner a 2/3 majority vote. Article 102B of the Constitution provides that a person is not qualified for election as president unless that person is B, not less than 35 years and not more than 75 years of age. Born in 1944, President Museveni would not have been qualified for election as president under the Constitution as it stood in 2017, as he would have attained the age of 75 years in 2019, the next general election being due in 2021. With this brief background, which I shall expound on later in this judgment, a member of parliament, Mr. Raphael Magezi, I will use Mr. Following the format in the Hansard and not honorable. Mr. Raphael Magezi, on the 3rd of October 2017, brought on the floor of parliament a motion to present a private member's bill, herein referred to as the impugned bill, to amend Article 102B of the Constitution to remove the 75 years presidential age limit. Apparently, this was intended to enable the president seek another term in office in the next general elections, should he desire to do so. In the same bill, Mr. Magezi also sought to have a constitutional amendment so as to incorporate therein the recommendations by the Supreme Court in Amama Mbabazi versus Yoweri Museveni and others, presidential election petition number 1 of 2016. As expected, the members of the opposition parties in parliament, some independent members and a few ruling party members strongly opposed the move to have the constitution amended. However, the majority of the ruling NRM party members supported the motion vigorously. The bill, after amendments, was passed into law and assented to by the President on 27 December 2017. Its commencement date is 5th January 2018 as Constitutional Amendment Act number 1 of 2018. The petitioners in the above considered petitions filed their respective petitions in this court challenging the constitutionality of the entire process leading to the passing into law of the said act, herein referred to as the Impugned Act. They also challenged the constitutionality of the act itself. So I go through the petitions. I do that. I have found it imperative to set out a historical background of the Constitution of Uganda, to give light to the reasoning behind the determination of the issues in accordance with the principles of constitutional interpretation set out above. Historical and constitutional background. Uganda has had a checkered constitutional history. On the 22nd of March 1894, the British government formally annexed Uganda and declared it to be a protectorate. By this declaration, Uganda came within the ambit of the Africa Order in Council of 1889, which authorized that as from the 9th of October, the territories comprised in the Uganda Protectorate will together form part of Her Majesty's Dominion with the name Uganda, and henceforth Her Majesty's government will have no responsibility for the government of Uganda and no act of the end. Then he issued legal notice number 1, again suspending Article 4 of the Constitution and Article 5 under that legal notice. Following the assumption of the National Resistance Movement, the government expanded the National Legislative Council in 1989. It extended their term was extended to allow a constitutional making process to begin. The government then proposed a new constitution to be enacted, one that would embody the views and aspirations of the people of Uganda. In this regard, a constitutional commission was established in 1988. It was headed by Benjamin Ndoki, a judge of the Supreme Court and a prominent jurist. It was called the Ndoki Commission. The terms of reference was to develop a constitution based on consensus, to ensure the widest possible popular consultations ought to educate the people about the Constitution and constitutionalism, enlist views of all the people, reconcile opposing positions with the view of developing a consensus, and ensure that the people generally both understood the constitutional issues and were committed to the views they submitted to the Commission. The Commission, for a period of 4 years, 1988 to 1992, traversed Uganda and sought the views of the people who were able to give them. The individuals, groups, and political parties, academicians, and people of all walks of life. It produced a report on 31st December 1992, which is annexed to petition number 3 of Uganda Law Society versus Attorney General. I have no intention of reproducing that report here. It is 800 pages long. I will endeavor to reproduce excerpts therefrom as far as they are relevant to the issues before me. As way of introduction, the report at page 55 and 56 states thus. I'll just read a few relevant parts. Above all, the concrete implementation of the principle of participatory democracy, which has given a powerful voice and active participation to the hitherto voiceless and oppressed sections of our society, it seems by most people as a tremendous opportunity and the new vision for the reconstruction of Uganda. It goes on. Lessons from history, both remote and recent, are the sure guide to the present and the future of our nation. All chapters in the report give summary historical insights to the topic treated. The aim is to recapture the lessons from our past. It is only such an approach that can assist us to avoid the mistakes and pitfalls which have hindered our unity and development, while identifying the values which have, despite problems, brought us where we are today as a nation. So I reproduce the observations of the people. There is concern that the legislature has often been not been the representative of the people. During much of the time since independence, appointed, usually self-appointed individuals of both bodies have taken over the powers of the legislature. Even when there has been elected legislature, bodies and the principle of elected representative has been watered down through additional numerous appointed members. Poor quality. Some elected members of the legislature have been found to be self-seeking and corrupt. 3, our post-independence legislatures have extended their terms in office without restitution. We must always recall our history, lest we forget. Indeed, lest we forget our people who shed blood in battle, who were killed and starved during the colonial wars, those who were killed in battles, those who were killed at Mengo, at Nakulabye, those who were deported from their homes to distant places, those who were killed during the regimes of Amin and Obote, those who lost their lives during the time to overthrow Amin. We must remember our history. The history of the people of Uganda is what we are recalling in the preamble in this constitution. That is why the preamble refers, when it calls us to recognize our struggles against the forces of tyranny, oppression, and exploitation. In this constitution, unlike any other, the people are sovereign and affirm their sovereignty and their inalienable right to determine the form of government they want through their constitution. In this regard, the constitution itself is not supreme. It simply embodies the supremacy of the people who, through an armed struggle, captured power from tyrants and dictators and vested it in themselves and set their will in the Constitution. They are the ones who gave Parliament the power to make laws, the judiciary to adjudicate on cases, the executive to pass and implement policies. The Constitution did not make the people. They made it themselves. Each and every provision of the Constitution of this country ought, by necessity, to be understood, interpreted with the knowledge of our history and the spirit set out in its preamble, the national objectives and directives of state policy as enshrined therein. With this background, I now proceed to determine the issues. We are urged together by the petitioners and Council Mabirizi. There are 14 and they have already been set out. I will not go there. Basic structures. Whether the extension of the term of Parliament and local council to 5 years from 5 to 7 is unconstitutional. Whether the basic structure doctrine applies to Uganda. The petitioners contend, firstly, that the procedures adopted by Parliament amending the Constitution was unconstitutional itself. Secondly, that the Parliament has no power to extend its term and that of local council, as in doing so it would destroy the basic structure. I will deal with the latter argument first, as it has the capacity of disposing the former. I will reproduce Articles 1 and 2 of the Constitution. It was submitted by Mr. Wandero Gallo that the Constitution provides that they would be members for life upon death. Their parliamentary seats would be inherited by their children. They cannot do so. They cannot do so because the Constitution put this court in place to stop them. This court shall not stand by and let our country's democracy and hard-won values set out in the Constitution wither on the vine. That will not happen on our watch. Members of Parliament have no power on their own to legislate. The power to legislate belongs to the people of Uganda. Every 5 years, they delegate it to some amongst themselves under Article 1. This power, therefore, delegated as it is very limited in both time and scope. Clearly, the notion that Parliament has unlimited power to amend the Constitution does not appeal to me in the least. The notion that every article of the Constitution can be amended has no legal basis in our history and jurisprudence. It must be rejected, and I hereby reject it. I would, on that basis alone, answer issues 1, 2, 3, 4 in the affirmative. Be that as it may, I need to consider 2, 6, 8, and 10, issue of public participation. I did find that there was no public participation whatsoever. They were incorporated in the bill, which was eventually enacted as 2, 6, 8, and 10 of the Act without any input from the public. The public participation alluded to by the respondent in their affidavits in support to the answer to the petition had nothing to do with those sections, because at the time the consultation took place, those sections had not yet become part of the bill. There was no question that those sections were introduced. Extending the term of Parliament 5 years were passed on the same day. No consultation was possible or had been done by members of Parliament. My reading of the answer suggests to me that the majority of the members were unaware of the amendments introduced by Tusime. Even fewer understood them. It appears to have been a well-planned ambush, premeditated and executed by a few backbenchers with the tactical support of the Deputy Attorney General and other frontbenchers. This is evident from the clandestine way a certificate of financial implication was requested for and issued without the knowledge of the Clerk of Parliament. They were brought up the floor of Parliament to appear as if they were a result of a debate, whereas not. Even members of parliament present at the time of the amendments were introduced were not availed time to debate the proposed amendment. I find that there was no public consultation at all in respect of this bill. Mr. Mwesgwa Rukutana, Land Attorney General, suggested, tongue-in-cheek from the bar, that the members of parliament had been able to consult the people through social media and electronic media using their newly acquired tablets, computer devices. This was evidence from the bar, which had no value. This statement just helps to confirm the level of unseriousness and cynicism members of parliament and executive attached to the constitutional duty to consult Ugandans upon whom the supreme authority vests in this constitution. The question I must determine is whether lack of public participation vitiates the process, and I have said that it does. Whether financial matters in this, Article 93, whether it was complied with. While submitting, Mr. Wandero Gano, Land Council.
Thank you, my lord. We will have a 5-minute health break. So I believe the Attorney General will not lead you out. We'll come back and then my lord proceeds.
To start serious parliamentary business. During the 4th year, members of parliament are preparing for primaries within their political parties for another election, and the 5th year is eaten up by the general elections. This means parliament has only 1 year to engage in serious parliamentary business. This justification for extension of term of parliament has absolutely nothing to do with the will and aspirations of the people of Uganda. It is blatantly in self-interest of the members of parliament, and as I have already stated, it is irrational. The people of Uganda did not elect members of parliament for them to go and learn parliamentary rules and procedures for 2 years. That is why the law provides for minimum qualifications of members of parliament. Mr. Tusime appears to suggest that members of parliament are either unknowledgeable or unqualified. I do not accept that our members of parliament are unknowledgeable or unqualified. All members of parliament are well qualified. The majority of them have postgraduate qualifications. It would not be an exaggeration to state that parliament has a concentration of the best brains. There is no absurdity in supposing that parliament passed legislation. There is no absurdity in supposing that had parliament passed legislation tightening qualification of its members, the constitution would have, in this respect, been left intact and the ends of justice would have been met. I am unable to find any reasonable justification as to why members of parliament would amend the constitution to grant themselves 2 more years on top of their current 5, simply to get acclimatized in parliamentary procedure, conduct, and business. Having done so, for the Honorable the Deputy Attorney General to simply insist that the amendment was a reflection of the will of the people whom the members of parliament had contacted using iPads. The reason why parliament was to give justification for passing of a law is a legal requirement that the law must be rational. I go to Article 8, it requires that the law be rational, and I say it is not. Reintroduction of term limits, I find that the reintroduction of term limits, again, did not comply with Article 93 of the Constitution, was not debated by the committee, was not consulted upon by the people of Uganda, and therefore I find that its passing was unconstitutional. Whether that is Article 102 and 183, and the second was the recommendations of the Supreme Court in Amamba Baba's UNM7 case. None of the petitioners presented serious challenge to the constitutionality of the original bill as presented. I have already found that it was not in contravention or inconsistent with Article 1, 2, and 8 of the Constitution. I also found that there is evidence that financial implication certificate was properly obtained. There was argument that because it was the Attorney General is the one who was directed to file the bill by the Supreme Court, that nobody else could. I don't find this argument valid. I now proceed to determine whether the impugned act, the Speaker of Parliament was alive to the fact that a constitutional amendment could not be made without consulting the people. And the question becomes whether in passing the amendment as a whole, the whole act, the people were consulted. I find that on Wednesday, 27 September, Raphael Magezi presented a bill. On Wednesday, 20th December, that bill was passed into law. On 20th December, that it was assented to by Parliament. From beginning to end, the whole process took 85 days, including weekends and public holidays. The bill was before Parliament on the following days: 27th September, 3rd October, 18th December, 19th December, and 20th. A total of 5 days. The bill was read out for the first time on 3rd October. It was then referred to a Committee of Legal and Parliamentary Affairs. The report of the committee was received on 18th. The debate on that day, and it was debated on that day and the following day, 19th. It was passed on 20th. The committee had 75 days to do that. Through the whole process, it had 75 days. Maybe if you remove the days which it was to sit down, consider, and write, you could remove about 15 days and remain with 60. I do not consider 2 months to be sufficient time for Parliament to seek views of Uganda, taking into account the following facts. In 2016, there were 15,277,198 registered voters. Okay. There were 290 constituencies. There were 112 districts. There were 1,403 counties. There were 7,431 parishes. There were 57,842 villages. In addition to the above, there are statutory bodies at all levels: women's groups, youth, civil society organizations, church organization, Muslim organization, professional associations, student associations. But the people who appeared before the committee as set out at page 4 were, I don't want to just, that the above persons and groups are the stakeholders representing the whole people of Uganda as a visit under Article 1 of the Constitution, in view of our past history, is unfortunate to say the least. I must state here that I have restrained myself from using the stronger language. I say so because the Electoral Commission statistics of 2016 general elections I have reproduced above, since a number of persons consulted as individuals were only 22, it means they represented 0.00013% of the registered voters. Even if 455 members of Parliament were added to this list, assuming they were all consulted, there would be 0.8% exactly to be of the registered voters of 2016. I am alive to the fact that passing a bill does not require input of every individual Ugandan, even every member of Parliament. However, every bill requires public participation that is purposeful, well-intended, and meaningful. What happened in this case appears to have been just window dressing, even that a clumsy one. The framers of our Constitution, the people of Uganda, were not contented with simply the right to vote in a free and fair elections as the only expression of their will. They expressly provided in the Constitution for a wider role in the democratic process by the people. Articles 1, 2, and 8 of the Constitution, the people reserved for themselves the role in the legislative process, as had been echoed by President Museveni in his maiden speech on the steps of Parliament on January 29, 1986, which I have reproduced earlier in this judgment. The same sentiments were repeated by the people during the constitutional making process and set out in the Doki report. That we call a smart test, that Parliament should use a test that is specific, measurable, has results that are attainable, that is relevant and time-bound. And I've looked at they have 8 affidavits, which Muhanga, Margaret, Jane Chibirige, Kakoza, Baryeku, Lokeris, Musasizi, Ongaro Bote, that people of Uganda did participate using the objective test. Now, I've looked at the subjective test because I've said that I've looked at the number of constituencies which the affidavits relate to, the number of sub-counties which the affidavits relate to, and find they were too insignificant to conclude under the subjective test that they constituted a number of the population that can be said to have constituted a meaningful participation. I then took on the objective test and said, an ordinary Ugandan on the street, if he looked at these facts, would he agree, would he come to the conclusion that the Parliament, before passing this act, the whole of it, took into account the views of the people or allowed the people to right of public participation? I have looked at Lord Diplock's dictum of a reasonable man, and I've said whether a reasonable man in Uganda would say that that was so. I have tried to define a reasonable man and say the reasonable man in Uganda is one who has a national identity card, a mobile phone, listens regularly to radio, attends LC meetings, has a job or attends to his garden or business, rides on a boda to town, and takes his children to school. And I ask myself, an ordinary Ugandan of this nature, can he positively state that there was reasonable and adequate participation in the legislative process that resulted into the enactment of the Impugned Act? And I answered it in the negative. And on that account alone, I find that Parliament failed to encourage and empower, facilitate public in participation of all citizens in the process of enacting the Impugned Act, and that contravened Article 1, 2, and 8 of the Constitution. And this very act vitiated the whole Impugned Act.
Please behave yourself. This is Mr. Mabili. Just a moment, my lord.
Whether police and the army.
My lord, just a moment. There's a code of behavior which we all know. You can laugh inside yourself. This one was springing up as if this is a political rally. This is not a political rally. Yes.
The intervention of members of Parliament prior and during the process created an environment that precipitated and eventually led to the intervention of the army and the police. It is likely and indeed probable that neither the police nor the army would have had reason to come to do so if members of Parliament had not conducted themselves in the way that they did. However, in view of our history, the hasty intervention of the army was uncalled for. There was no evidence whatsoever that whatsoever requiring its intervention, as the police force of Uganda is equipped and professional enough to evict unarmed people from a building that is not even on fire. Our history requires that the army be kept out of partisan politics. During the constitutional making process, the people expressed the view that the army must be kept out of politics. I have already reproduced the excerpt of Odoki's report in this aspect. The police is subject to the law. The petitioners have set out the affidavits wide-ranging allegations against the police, degrading treatment of citizens by both Roman citizens 2,000 years ago could not be subjected to a cruel and humiliating punishment. I set out the story of St. Paul when he was about to be flogged and put in chains, but when they realized that he was a Roman citizen, the magistrate and the army commanders panicked because a Roman citizen could not be put in chains. If a Roman citizen could not be flogged 2,000 years ago, how can a Ugandan citizen, a member of parliament at that, be beaten publicly by police officers and subjected to cruel and inhuman treatment? This must stop. The way they now routinely do, which this court takes judicial notice of as being a notorious fact. This is completely unacceptable and it must stop forthwith. The Attorney General must ensure that this is brought to an immediate end. Today, members of parliament are flogged. Tomorrow, it shall be a minister. And then, God forbid, the Chief Justice. We would have gone full circle. If that action of the police and army in forcefully evicting members of parliament from chambers and arresting them after manhandling them, I find that the action of the police and the army in forcefully evicting members of parliament from chambers and arresting them and manhandling them violated the Constitution. In my considered view, the Speaker of Parliament should have simply adjourned the House to the next day. Then the Sergeant at Arms would have denied entry to the members who had been suspended. Members of Parliament who were injured and manhandled or otherwise mistreated are at liberty to seek redress in an appropriate court of law. Having said that, the question is whether the intervention of police and army in Parliament had the effect of vitiating the entire process. I have gone through this. She stated in her testimony in court that she returned the money. All she did was to write a check, which was never cashed. She knew very well at the time she came to court to testify that the money never left her account. She did not appear to be a truthful witness. I can safely conclude that since members of parliament were given money, they accepted it, they were free to consult the people. All in all, no sufficient evidence was provided to prove that members of parliament were prevented from consulting the people. Before I leave this issue, I'm constrained to comment on the 29 million. I must state that that money must be accounted for by the parliament's accounting officer in respect of members of parliament with constituencies. In respect of members of parliament without constituencies, they must refund this money or it should be recovered from them through a process established by law. Having stated that, I must reiterate what my brothers have stated, that the police had no powers to issue directives stopping members of parliament and specifically members of the opposition in parliament from consulting the people of Uganda. The police officer who issued that directive ought to be brought to account by relevant authorities. This is a free and democratic society. It is not a police state. The Public Order and Management Act must be implemented subject to the Constitution. The act of the police issuing a letter violated Articles 1, 2, 23, and 29 of the Constitution. Whether the consultation were marred by restrictions, I find that they were not, but I say that the police directive was issued in complete and total disregard of the Constitution. The police appears to have acted and continues to act as if this country has no constitution. They assume quite wrongly that a police officer, being a police officer puts one above the law. The police has no power to curtail liberty of Ugandans except as provided for under the Constitution. The police message does not mention under what law it was issued and how it was to be implemented. It criminalizes intent. It goes against every letter and spirit of this Constitution. It takes us back to the dark days of the past, which I have attempted to set out earlier in this judgment. By directing the police to stop intimidating persons perceived to be supporting the removal of the age limit, Without issuing a similar directive in favor of those who were supporting the age limit removal, the police acted in a partisan manner. In the process, it also criminalized an otherwise legitimate political issue. By criminalizing a section of society, in this case, the people who did not support the removal of age limit, the police pursued an extremely dangerous path. This kind of trend is what our constitution was put in place to stop. The police directive violated the promise of freedom and liberty the president gave to the people of Uganda in 1986 at the steps of parliament when NRA took power. Throughout the early colonial period, perhaps up to 1955, the colonial policy of discrimination and criminalization affected all the people of Bunyoro. Many had to change their names, dropping Bunyoro names and adopting Chiganda ones. More than 3/4 of the population of Bunyoro was killed or starved during the Kabarega Wars, leaving empty land that was turned into national parks and game reserves by the colonial government. There was also discrimination and marginalization of Catholics during the colonial period. From 1966 to 71, there was widespread criminalization of Baganda and the members of the opposition Democratic Party and Kabaka Yeka. From 1971 to 78 and 19 of Act 1 of 2018 is unconstitutional and therefore null and void. All its provisions ought to be expunged from the Constitution of Uganda. 2, the petitioner shall be paid costs as directed by the Chief Justice, Deputy Chief Justice. Recommendations. Before I take leave of this matter, I would like to make the following recommendations. That in view of the fact that there are pending a number of parliamentary motions seeking to introduce private members' bills, proposing a number of constitutional amendments, and in view of the observations of the Committee on Legal and Parliamentary Affairs, a number of stakeholders had recommended that the Constitution should be amended after establishment of a Constitutional Review Commission. Further, in view of the recommendations of the Supreme Court in Amama Babas versus YKM 7, there is urgent need for the Attorney General to bring before Parliament a proposal to constitute a Constitutional Review Commission under the Commission of Inquiry Act, detailing therein terms of reference for amendment of the Constitution. That commission be tasked with the duty of seeking views of the people of Uganda in a period of not less than 6 months on all proposed amendments and make proposals to Parliament. 2, a similar commission of inquiry be set up to investigate, determine, and make recommendations regarding the apparent brutality of the police against the citizens of this country with the view of seeking a remedy to this mischief. 3, government provides funds for this purpose. 4, the Attorney General issues within a period of 6 months from date hereof guidelines to police in the implementation of the Public Order and Management Act, and a copy thereof be submitted to this court. 5, the Auditor General carries out a forensic audit of the accounts of the 10th Parliament, and the resultant copy be submitted to this court and the Minister of Justice and Constitutional Affairs. I so recommend, and I thank you.
Thank you, my Lord. We will now hear Lord Justice Remy Kasule deliver his judgment.